Hello, I'm District Judge Thomas Mulvihill with the 20th Judicial District. I'd like to talk to you about probation revocation hearings. To initiate a revocation of probation, a complaint to revoke probation must be filed by the probation officer or the district attorney that alleges a violation of one or more of the conditions of probation. The complaint must state the date, place, and nature of the violation, and probation may be revoked if a probationer violates any condition of probation. The revocation must be initiated, that is, a complaint must be filed or an arrest warrant issued prior to the expiration of the term of probation. Otherwise, the court loses jurisdiction to hear an allegation that the probationer violated probation. At the probationer's first appearance, the court should advise the probationer of the nature of the allegations in the complaint, the possible penalties, the right to bail, the right to a hearing, the right to remain silent and that anything said may be used against the probationer, the right to counsel and to the appointment of counsel if the probationer is indigent, the right to cross-examine any witnesses that testify, the right to present evidence, the right to testify, and that any admission to the complaint must be voluntary and not the result of undue influence or coercion. After the advisement, the court must require the probationer to admit or deny the allegations in the complaint. If the probationer admits the allegations, the court should revoke probation and then proceed to sentencing, which may be done immediately or after the preparation or update of a pre-sentence investigation report. If the probationer denies the allegation, then the court must set a hearing. Where the probationer is being held in custody as a result of the probation complaint, the hearing must be held within 14 days. That 14-day requirement may be extended at the request of the probationer or for good cause. At the revocation hearing, the prosecution has the burden of proof. Commission of a new crime must be proven beyond a reasonable doubt, unless the probationer has already been convicted in a criminal proceeding. If the alleged new crime is still pending, the court may continue the probation revocation hearing until resolution of the alleged new crime. All other probation violation allegations must be proven by a preponderance of the evidence. At a probation revocation hearing, the Colorado rules of evidence do not apply. Any evidence having probative value should be received. Hearsay evidence is admissible so long as it has some indicia of reliability. The constitutional right to confrontation under Crawford does not apply at a revocation hearing, and evidence that is entirely hearsay can be sufficient to establish a violation, as long as the defendant is afforded a fair opportunity to rebut the hearsay evidence. A probation revocation hearing is a simplified trial to the court. A probationer is not entitled to the full range of constitutional rights and protections that are available to an accused who is not yet convicted. The probationer has no right to a jury trial on the allegations in the complaint. Counsel need not give and the court need not hear opening statements. The prosecution is obligated to present evidence, which they may do through witness testimony, by judicial notice, or by stipulation. The rules of evidence are relaxed, and hearsay evidence may be used to establish a probation violation. The court can take judicial notice of its own file. The defendant is entitled to cross-examine each prosecution witness. After the prosecution rests, the defendant may make a motion to dismiss the complaint, similar to a motion for judgment of acquittal. The defendant may present witnesses or other evidence and may testify if they choose. The defendant is not entitled to a courteous advisement before testifying. The defendant may, on cross-examination, invoke the Fifth Amendment right against self-incrimination, but the refusal to answer may be considered by the court and against the defendant. The court may allow rebuttal evidence if appropriate, and the court may, but is not required to allow closing arguments. The court must make findings of fact and conclusions of law that support its determination. That determination is whether or not the allegations in the complaint have been proved or have not been proved. If the court finds that the allegations in the complaint have not been proved, then the court should reinstate probation for the remaining period of time and under the original terms and conditions. If the allegations in the complaint have been proved, then the court should revoke probation. Understand that after finding a violation of probation, By rule, the court has 7 days to determine whether to revoke or continue probation. Most courts make the decision immediately. If probation is revoked, then the court needs to set the matter for sentencing, and at that time, you may order an original or updated pre-sentence investigation report. If probation is revoked, the court may impose any sentence or grant any probation that could have been originally ordered. There are several circumstances that you will run into frequently, and so I'll mention them here. Where the probationer is alleged to have violated probation by not making payments as required by a condition of probation, the prosecution must also prove that the probationer had the ability to pay the money and refused to do so. Understand that probation orders take effect upon entry, and if the probationer appeals the underlying conviction, the probation terms and conditions remain in effect pending appeal unless the trial court grants a stay of probation. Where there is no stay of probation, the trial court retains jurisdiction to adjudicate a probation revocation complaint while an appeal of the underlying conviction proceeds. And finally, if you are dealing with the revocation of a lifetime supervision sex offender, be aware that Colorado statutes require the probation officer and the probationer's treatment provider at any revocation proceeding to submit recommendations regarding the level of treatment and monitoring that should be imposed if probation is not revoked, and whether the probationer poses a sufficient threat to the community such that probation should be revoked. The court must consider the recommendations of the probation officer and the probationer's treatment provider. If the court chooses not to follow the recommendations, it must make findings on the record in support of its decision. Failure to make sufficient findings is reversible error.